everyone. Good afternoon. Thank you so much for joining this edition of a live event from Silver Talkies portfolio. We have had a few sessions earlier as well on this topic, but I think we can never have enough of creating awareness about this particular subject, given it's such an important one, but we still do not understand it fully. So thank you for dropping in. So a quick introduction to Silver Talkies in case you are here for the first time. We are a community and engagement platform designed exclusively for older adults. So we have been working in the space of ensuring that active aging is something which is possible for all older adults for the last decade now. And we have members in Bangalore, in Chennai, in Mumbai, Hyderabad, Pune, and in Delhi, NCR, and also in cities like Coimbatore, Lucknow, Chandigarh. So we have a club which is meant to be a social networking and an engagement club for people. It's called the Silver Talkies Club. So if you're 55 plus, you can always join the club to get to know and meet more like-minded individuals like yourself. And we run a lot of sessions like what you're attending today online. So we do a variety of sessions around creating awareness, around skill building. We have tech classes. We have a lot of hobby classes that happen, a quizzing session, storytelling. So it's a very diverse calendar that we have every month. We also have interest groups, 5 interest groups where our members get together once every month to discuss that interest. So we have interest groups. We have a book club. We have a knitting and crochet club. We have a music hub, and also around sports. And so you do have a lot of opportunities where you can bond with people. And we also do understand that just staying online may not be sufficient. So we do have meetups which happen once every month in our city chapters, the cities that are just the main 6 cities that are in, kind of counted earlier. So our members meet every month over an activity. So actually every third Friday of a given month, we have a meetup. So in fact, this Friday, our members across different cities, across 6 cities, are going to catch up doing different activities. So for example, the Bangalore team, the Bangalore chapter members are going for a movie and would be catching up over lunch. The Chennai members are going to play board games at a games cafe in Chennai. Pune members are meeting at a cafe. And Delhi members are going to a museum of illusions followed by a coffee catch-up. So like that, every meetup is different, from what it may have happened in a previous month. So yeah, so if this is the kind of lifestyle that you want to have as in your growing years, in your aging years, you're most welcome to look us up at silvertalkies.com. And consider this as a invitation from all of us here at Silver Talkies to join us at the club and really enjoy the fun party that we have here. But in the interest of time, I actually would have invited probably some of our members to talk about the club and what they do and what is how do they enjoy themselves. But I'll stick to the agenda for today. So let me welcome Mr. Shiv Kumar. He is a senior advocate with the Karnataka High Court. And he has been very instrumental in running a lot of things. I'll just bring up his introduction. Just give me a second. So I don't know if some of you have already attended Shiv's talks previously that we've had, because we've had many opportunities of inviting Shiv on our platform. He also happens to be a member of the Silver Talkies Club. And previously he has, given sessions on the concept of will writing. What is it that you should bear in mind? What are the nuances of will writing? And also he speaks very passionately about the topic that we have today. He also he also was very instrumental in setting up the elders helpline that we have in Bangalore, with the police commissioner's office, which was 18 years ago. And he offers pro bono legal services for the have-nots of society. He's a certified mediator. He's a master trainer in mediation. He's also been very so he goes to the mediation center very often and helps out resolve family issues. Apart from being a certified mediator, he's also a designated master trainer at the Bangalore Mediation Center, which is an initiative of the High Court of Karnataka. He also authored a draft legislation, which was, exclusively for elders and was presented for public discussion. And the existing law has drawn substantially from such legislation. So I'm guessing all of you may be aware of the Maintenance Act. So he has also been part of that committee which recommended the amendments to the existing Maintenance Act. Now, beyond his professional pursuits, he's also a theater artist and he's acted and directed several plays in English. He's also acted in Hindi and Kannada TV serials. So a very warm welcome, Shiv, and thank you so much for finding time for us all over again.
Good afternoon. It's always nice to be with Silver Talkies, primarily because Nidhi has nice things to say about me. It gives my ego a great boost when she talks about me in the terms that she did. Thank you very much. Let's see what we can do with the subject today. But let me begin by warning you that this is a very morbid subject. The moment we talk about wills or living wills or advanced medical directives, the entire platform on which this is based is very morbid. It's about death. It's either about before death or after death. So let me caution you that during the course of this presentation and the questions that you may have for me later, this word death and end life will be repeated quite often. So do be prepared to listen to this specific word as many times as I may be using it. There is no reason to get completely dejected because this whole subject is intended to make end life more comfortable for us when the time comes for us to depart. So with that caveat, let me begin. What is a will? There is a huge misconception that the concept of a living will or the advanced medical directives as it's now been known is the same thing as a will as we generally understand it. In our daily conversations or wherever we meet, particularly people who are aged and elderly, are constantly worried about wills. The wills that are referred to in those conversations are not the same thing, which is the subject matter of the discussion today. A will is a testamentary document. When we mean a testamentary document, it means it comes into effect only after the death of the person who is making that will, as contrasted to a non-testamentary document. A non-testamentary document is like a sale deed or a gift deed or a mortgage deed or a lease deed. These are all made during the lifetime of the testator or the person who's making the will. Whereas a testamentary document, as we understand it in normal language, is a document that will come into effect only after the death of the maker who makes the will. Now, a will, as we generally understand it, records the testator's wishes. A testator is a person who makes the will, by the way. So that is a technical expression for a person who makes the will. He's a testator. A will, generally, when we talk about a will, talks about or records the testator's wishes or intentions regarding the disposal of his assets after the death. And when we talk about assets, we talk about movable assets, we talk about immovable assets, we talk about bank balances, fixed deposits, properties, movables, television, gas connections, property rights, copyrights, etc., etc. But the fundamental distinction or the fundamental concept of a will is that it will come into effect after the death of the person who makes the will. And when we talk about this general will that we're talking about, it can relate either to the present assets that you may have, or it could include any future asset that you may acquire after you have made the will. And as I said, the will comes into effect only after the death of the testator. If you do not make a will, we do not get into the situation where we do not make a will, the personal law of succession will apply. For example, Hindus who die without making a will, there is an act or a statute known as the Hindu Succession Act. The provisions of that act will automatically apply. Similarly, for people who follow the Parsi religion, there is a separate law. For people who are Mohammedans and Muslims, there is a separate law. For Christians, there is a separate law. So this is known as testate and intestate succession. A testate section is one where a will is made by a person. And an intestate succession is one where he dies or she dies without making a will. In the case of a will, you can direct how your assets can be disposed of, to whom the property should go, in what proportion it should go, and so on. But if you do pass on without making a will, the individual law of succession will apply, which may not necessarily be in consonance with your wishes, because that is statutorily confirmed. Now, contrast this with a living will. We commonly use in society, most people use the word living will. This concept of a living will has not yet been recognized in India. But this term, this whole concept of making a living will, came into public domain in the case of the Common Cause versus Union of India in 2018. Now, the genesis of this whole living will concept lies in what we call Article 21 of the Constitution of India, which talks about the right to life. The Supreme Court of India has interpreted this right to life in multiple ways. It has constantly engaged itself in broadening the concept of right to life. It does not simply mean that the way you live must be with dignity. It also expanded this concept into saying the right to life also includes the right to die with dignity. So until 2018, the concept was that the right to live means the right to livelihood, the right to a clean environment, the right to live noise-free environment, and so on and so forth. But for the first time in 2018, the right to life was expanded to include the right to die also with dignity. And this was the case of Aruna Shanbag. The case arose in 2011. And the case of Aruna Shanbag, I'm sure all of you have read about it. She was in a permanent state of vegetation for over 18 years in the Bombay hospital. And it is that stage at which Common Cause, which is a public trust, it filed a petition before the Supreme Court of India saying that keeping a person alive by artificial means offends the fundamental right to life, which means I must have a right to die with dignity. Now, the concept that was examined by the Supreme Court was euthanasia. The decision of the Supreme Court did not arise from the concept of a will or a living will. The foundation of discussion for creating this concept of a living will arose in the context of euthanasia. And in Aruna Shanbag's case, which was in 2018, as I said, she was in a vegetative state, a permanent state, vegetative state. And therefore, the question was whether you should pull the plug and let her die, or she should continue to live as long as her normal body was functioning with or without external support. Therefore, the Supreme Court examined the provisions relating to euthanasia in all other countries. The Supreme Court defined euthanasia to start with, and it said as follows, as you see it on your screen. Basically, it is an intentional premature termination of another person's life, either by direct intervention or by withholding life-prolonging measures and resources, either at the express or implied request of that person or in the absence of such approval or consent. It essentially talked about euthanasia as a process by which you pulled the plug, as we understand it in common language. You allowed the person to die, either by a positive act or by a negative act. It also created a definition. It said there are two kinds of euthanasia. One is known as an active euthanasia, and the second was passive. Now, when we talk about active euthanasia, it means a medical professional or any other institution takes positive action in destroying life. It is an aggressive action. In some of the countries in the world, this is permitted. Euthanasia by injection of a lethal drug is permitted. Now, that is known as active euthanasia. Passive is negative in its approach. It is non-aggressive. It simply means that you express and say that these are the medical condition. This is my medical condition. I do not wish to be given life support treatment. It's either withholding treatment. It is not actively assisting a person in the process of dying. That becomes active euthanasia. Passive euthanasia is a situation where I declare that I do not want these treatments. And therefore, let me go peacefully and die with dignity. The Supreme Court did not permit active euthanasia. So today in this country, it is not permissible for a medical professional to inject you or to take away your life by means which are known to the medical profession. What is permissible in the concept of euthanasia is passive. And it is on this paradigm, on this platform, that the question of a living will came up. Now, what did the Supreme Court say? Fortunately or rightly or wrongly, this is what the Supreme Court said. It said, be it noted, though the learned counsel for the petitioner has used the words living will, we do not intend to use the said terminology. We have already stated that safeguards and guidelines are required to be provided. The Supreme Court refused to recognize the concept of a living will. But what it did was to substitute it with the words Advanced Medical Directive. Throughout this presentation, therefore, whenever I refer to a living will, please do remember that I am talking only about an AMD, which is an Advanced Medical Directive. The living will does not have a statutory definition under the Indian law. And the Supreme Court said that unless the law steps in and defines what is a living will, we will not use that expression. We will continue to use the expression medical directive. And that is what we will refer to when we talk about the living will. Now, therefore, what is an advanced medical directive? An AMD is a substitution for a living will. As I said earlier, the Supreme Court has refused to accept the concept of a living will, and therefore it is a substitution for the words living will. It is essential to remember that under a AMD or a living will, a disposition of assets or property is impermissible. This is the difference between the wills that we originally ordinarily talk of, where properties can be disposed of. In the case of an AMD or a living will, there cannot be a disposal of assets or property of the person who is making the AMD. Organ donation, cadaver donation is not permissible under the AMD because the law recognizes a separate procedure for that. Organ donation and cadaver donation are governed by regulations that have been instituted by the hospital, and they have also to be made during your lifetime. Therefore, an advanced medical directive is restricted to withdrawal or withholding of medical treatment. That is all an AMD does, and that is all a living will is capable of doing. Statutorily, therefore, what you can do when you make an AMD or an alternate advanced medical directive is to specify what is the medical treatment that I'm willing to take, what is the medical treatment that I do not want to be subjected to just to keep me alive for years and years and years together. Now, in the absence of specific legislation for AMD, which we do not have at the moment, the guidelines laid down by the Supreme Court in the case of Shanbag, that is 2018, the guidelines is what will hold the field. To put it very simply, because we do not have a statute or a law passed by Parliament or the state legislature, the guidelines which have been laid down by the Supreme Court in the decision will what will control what is an AMD, how do you execute an AMD, what is the effect of an AMD, and how do you execute an AMD. Now, what are the perspectives that one actually looks at when we talk about an AMD? Assuming that you have by now understood what an AMD is, namely an Advanced Medical Directive that controls the kind of treatment that you want and you don't want. There are several areas which go into making a decision. One is the medical. The medical profession, for example, believes that that medicine and healthcare and doctors are intended to preserve life and not to take away life. That is the Hippocrates oath that the doctors take. Therefore, there is a conflict amongst the medical profession as to whether an AMD should be allowed or should not be allowed. But now the Supreme Court has recognized it and laid down an elaborate procedure which protects the medical profession and does not convert execution of an AMD into a criminal offense. They are protected. So that is the first perspective. The second is the legal perspective. The question is, the law steps in and says, we will permit you to take your own life, which is what it's doing. When I execute an AMD, the person who executed is telling the medical profession and the family that I do not wish to be, my life is not to be prolonged by artificial means. I want to end my life. Now, if you are one of those who wants to commit suicide, that's a different matter. It's outside the scheme and scope of an AMD. But you execute an AMD, you are telling a medical profession, you are telling a medical healthcare institution, do not give me this treatment. It does not matter if I die. Therefore, there are moral and ethical issues that arise both with medical profession and with the legal profession. Now, at the bottom of all this is your perspective. The person who makes the AMD or issues an AMD, what is his or her perspective on death? Do I want to live out my life? It does not matter whether I am under medical care, whether I am under life supporting systems, whether I am on a ventilator, but I do not want to end my life. Now, if that is an individual perspective that every person who wants an AMD to be made or not to be made, there is a conflict. That's a perspective that the maker of the AMD has to decide. That is your perspective. Now, while deciding whether you should make an AMD or not make an AMD, one of the factors that comes into is the family pressure, family opinions, family's views, and the peer views. Not so much the peer views, but certainly the family. Probably in most cases that we have seen, the objection to making an AMD or creating an AMD comes not so much from the person who wants to create it, but from immediate family members. Therefore, the family plays a very, very critical role in deciding whether you should issue an AMD or you should not make an AMD. Now, this is a perspective. I'm not sitting in judgment here saying this is wrong or this is right. It is a perspective because family members do want senior citizens amongst them, irrespective of whether the senior citizen or a person who is making an AMD wants to remain or not. This is a social factor. Therefore, that perspective actually hinders or in the making of an AMD. Then there is a post-event factor. When we talk about post-event factor, it means let's assume that there is an AMD that has been made. And in pursuance of the AMD that has been made by a person, it is given effect to. Translated into simple language, it means suppose the hospital where you're admitted or the physician where you're admitted decides to pull the plug because you have made an AMD and your family members and others agree to it, the guilt factor that may follow after the event is something which is to be recognized now, and people who are left behind should be prepared to face the consequences of that decision. These are all in the realm of individual choices that a person who makes an AMD has to decide. But I have put this on record just to bring to your notice that these are the perspectives that any of us who wants to make an AMD has to take into account before we actually get into the process of drafting an AMD. That brings us to the next question: who can execute an AMD? That's a living will. It can be executed only by an adult over 18 years of age. He has to be major. The Indian law defines a major as a person who has attained the age of 18 years, and therefore it has to be a person who is an adult. The next requirement is that this person must be of sound and healthy state of body and mind. This is the very critical factor. You have to be in a mentally sound state of mind and also in a physically fit state of mind when an AMD is created. For the obvious reason that if a person is physically in pain or mentally not in a fit state of mind, then the product that comes out of that, the AMD that comes out of that, may not be a document that is voluntarily made. A person in pain may take a lot of decisions which are otherwise not have been taken by him when he or she was in a sound state of mind, in a healthy state of mind. So what therefore the law requires is that you must be mentally sound, you must be in a healthy state of mind, both body and mind, before you execute an AMD. This, a person who makes an AMD must be able to communicate. Cognitive abilities must be in full working condition. This translates quite simply into saying that if a person was to make an AMD or issue an AMD or execute an AMD, that person must be able to comprehend the nature and purpose of executing that document. He must understand the consequences of the document, which is what we mean when we talk about cognitive abilities. If a person, for example, is under the belief that what he is executing is a power of attorney or a sale deed or a gift deed or any other document, but in fact he is executing an AMD, then it is a state where he is not able to understand, comprehend the nature of the document or the consequences of that document. Consequently, it would create a situation where the executant of the AMD is not in a sound state of mind because that person is unable to understand the consequences of that action. Therefore, these two are the extremely critical components which are essential, which is what we in law call the sine qua non, the essential features or the requirements before any person can execute an AMD. A sound state of health, both mentally and physically. Translated into simple language, as I said, it means a person must be able to understand the nature of the document he is executing, the purpose of that document, and the consequences of that document. The consequences of that document must be clear in his or her mind, namely that it is pulling the plug, namely that it is seeking the end of life. If these three conditions are not specified, then the AMD or the living will becomes questionable later and therefore may not be given effect to. There is no such thing as an oral AMD. Under the law, it is compulsory that it must be in writing. There is no specific format required, but what is required is a clear intention of the document, which specifies what is the nature of the document, what are the medical treatments that I do not want, and what is the nature of treatment that I'm willing to take. There is something known as informed consent in law. This concept of informed consent simply means that it must be executed voluntarily by me. A person executing an AMD must do so voluntarily, without force, without compulsion, without being compelled to do so, and we know the consequences of the document that he or she is executing. The voluntariness of execution can be subtle. It may be an emotional blackmail that you may be getting. It may be pressures from the family that will prevent a person from executing an AMD. Or it may be some other kind of emotional duress that is being put on you or the person who wants to execute the AMD. The concept of voluntariness is that the person who executes the AMD must be completely free and of his own choice and volition should have executed the AMD. There cannot be any kind of force, there cannot be any kind of compulsion, there cannot be any kind of inducement either. Where does this come from? The force need not be physical force. It need not necessarily be that you're confined to a room with a gun pointed at your head and said you will sign this document. No. Similarly with compulsion. There are a variety and very subtle forms of compulsion and force and inducement that immediate family members, beyond family members, your peers, and society in general can actually influence you. So informed consent means I must be in a completely free frame of mind before a person decides whether to execute an AMD or not. The another requirement when we talk about voluntary, it being voluntary, is that the person executing the AMD must have obtained full and complete knowledge about his medical condition. It is not a literary document. It is not an article that one writes. It is a document that is intended to have legal connotations, legal consequences. And therefore, it is incumbent that when an AMD is executed by any person, there is adequate knowledge of both the contents of the document, the purpose of the document, and the history of his medical condition before you execute that document. It is not only in the case of AMD that the concept of informed consent exists, it exists in every sphere of statutory contracts also. For example, if I agree that I would sell my house to B, and B and A have to be informed consent, which means I must be clearly aware that I'm selling my house. The person who buys my house must be clear that he's buying the particular house that I'm offering for sale. Unless both of us are clear that we are talking about the same thing at the same time, and I'm doing it voluntarily without any force or compulsion, it ceases to be a valid AMD and therefore ceases to be a valid informed consent. Now let's look at what is the contents. Just 1 minute. This document, AMD or living will, must clearly specify under what condition should no medical treatment should be given to me. Why? Because the medical treatment will only have the effect of delaying the process of death, which otherwise may cause me pain or anguish and suffering and put him in a further state of indignity. As I mentioned to you a little while ago, the whole concept of AMD is based on the concept of right to die with dignity. Therefore, the content of this AMD must clearly specify under what circumstances should medical treatment be given and not given. If it is a treatment which is going to simply prolong the process of death or give you more and more pain before death actually occurs, then you are entitled now, when you make the AMD, to specify and say, I do not want the following treatments to be given to me. Or that I want these specified treatments to be withheld when I'm in a state where it's going to cause me pain or anguish before I die. It must indicate in very clear and specific and unambiguous terms the circumstances under which you can withhold or withdraw medical treatment can be resorted to. These are essentially directives that are issued to the medical profession, either to your doctor or to the institution at which you are. Just like any will, ordinary will, which relates to property that requires specificity, is the same kind of specific content that is required in the case of an AMD. It must specify when medical treatment should stop. It should specify what are the medical treatments that should not be given. It can also specify what are the treatments that can be given. And finally, the AMD can specify at what point of time can this treatment be withdrawn. And when I talk about treatment being withdrawn, we talk about passive euthanasia, not active. An AMD cannot specify and say that you shall specify, the medical profession shall inject me and hasten my death process, because that is not allowed. It can only refer to and is therefore restricted to under what circumstances can medical treatment be withheld. Now, the content of AMD must state that the executor, when we talk about the executor, it means the person who actually signs the AMD. These are technical expressions. Therefore, we'll continue to use the technical expressions. It must state that the executor may revoke the instructions or authority at any time. In other words, what the Supreme Court says is you can execute an AMD, but that must also state that I can withdraw the AMD at any point of time that I want. The right to create an AMD carries with it the right to withdraw it. Let me draw an analogy for you. I'm sure all of you know that under the Constitution, you have a right to freedom of speech and expression. You can speak. But the law does not say that you must speak. The law also gives you the freedom to say that I do not want to speak. Similarly, the law here says, I give you the authority. You are entitled to make an AMD, but I must also give you a corresponding authority to withdraw that or to cancel the AMD that I have made. Now, the second thing that the AMD requires is that you are required to specify the name of a guardian or guardians or a close relative who is authorized to give consent to withdraw or refuse medical treatment when the executor is not able to do so consistent with the AMD. Let's say you're in a coma. Let's say a person who has executed an AMD is in a coma, or this person's cognitive abilities are far, far below what is required. Somebody would have to take a call as to what medical treatment must be given or what medical treatment can be withheld. Even though you have made an AMD, that AMD must specify either one guardian or two guardians or one relative or two relatives who will be authorized to give effect to the AMD by saying, do not give this medical treatment, withdraw this medical treatment. Which is consistent with the AMD or the living will that you've already made. This is a protective measure for the person who has made the AMD, because at the time of making that decision, the person or the executor who has made the AMD may not be cognitively in a position to take a decision. He or she may, as I said, be in a coma where they are not aware of what is going on. This is exactly what happened in the case of Shanbag. She was in a permanent state of vegetation for 18 long years, being unable to communicate. And she was kept alive on artificial means because the hospital said, we will take care of her. In that situation, there must be somebody on your behalf, on the executor's behalf, who will say, this is enough, you can pull the plug, because the AMD says you can pull the plug under the following circumstances. Therefore, the specifying the guardian or a close relative is an essential component of the AMD. The latest AMD will be given effect to. The law says you can make as many AMDs as possible, following from the first observation we made that an executor may make as many, he may revoke the instructions that are given in the AMD at any time. You can continuously make AMDs every third day, fourth day, fifth day, wherever you feel like. The latest chronologically will be given effect to. Now, this document has to be signed by the executor in the presence of two attesting witnesses who are preferably independent. What do we actually mean? What does the law mean by independent? An independent witness is a person who has no adverse interest either in your dying or in your being alive. Let's take a hypothetical example of somebody who is interested in your property, in your assets, and he or she is looking forward to hastening your death. Now, this is not a person who is independent. In other words, when we say a person who is an independent witness, should be a person who has no axe to grind in your death. Therefore, we require two independent witnesses who will witness your signing this AMD. And you would have to sign this AMD in the presence of these two witnesses. One of the observations that I would like to make to you here is, when we do select witnesses, when an executor selects witnesses, please take care to ensure that they are younger than you are, substantially younger than you are. Because if an 80-year-old is making an AMD, it's pointless having a 90-year-old person as a witness. Because that is in all likelihood, in all theory of probability, the 90-year-old would precede you and he would have gone or she would have gone before you pass on. Therefore, our experience and our suggestion is that please do select independent witnesses who are younger than you are. This AMD and living will preferably should be signed in their presence. They should be present when you sign the AMD. They should affix their signature also on the AMD as witnesses at the same time, at the same place, and on the same date that you execute the AMD. Why do we as legal professionals recommend these measures? Is to avoid a situation where in future, when the AMD has to be given effect to, the validity or the circumstances under which it was executed is not questioned or challenged by anyone. So these are the guidelines of the Supreme Court. This guideline, the AMD or the living will is required to be signed before a gazetted officer. Now, a gazetted officer is a person whose appointment is notified in the official gazette. Your government officers, any government officer, your government teachers, these are all gazetted officers. But the law was amended by the Supreme Court recently, and it said you can execute this document before a notary public. There are hundreds of notary publics all over. Either you go to the notary public or the executant insists that the notary public comes to the house, that facility is also available. A notary public is a person appointed by the central government or the state government who is authorized for this purpose of signing documents, of signing affidavits, and so on. Therefore, this AMD can be executed before a notary public. What does this mean? It means that the person who executes the AMD would have to appear before a notary public. Physical presence may become necessary. But if the executant is not in a position to move out physically, there is a provision, as I said, under which the notary public can be requested to come home and you can execute that document before the notary public at a cost, of course. There are specified fees that will have to be paid. Now, every notary public under the law is expected to maintain a book. And in that book, there is a detailed or at least a synopsis of the documents that he or she has notarized. That register contains a provision for giving your AMD a document number. Therefore, what the executant has to do is to execute this document before a notary public, ensure that the document gets a number which is allotted by the notary public, and that an entry of this document is made in the register that he has maintained. Please ensure that this document, the AMD, carries the seal and signature of the notary public. If there is payment made to the notary public for his visit or for the execution of the AMD, there is a receipt that the notary public has to give you. Kindly keep and preserve that receipt, because these are all documents and circumstances that would at a future point of time ensure that the document is a verified document, it's a valid document, and may be given effect to as prescribed under the rules. Now, what is it that the gazetted officer or a notary public has to record? This is up to the person who executes the document, executes the AMD. It is necessary that the following sentence be included in that document by the notary public or the gazetted officer. And that sentence is, the document has been executed voluntarily and without any coercion or inducement or compulsion, and with full understanding of all the relevant information and consequences. You remember we did talk about informed consent. We talked about a state where the executant must be in a healthy state of mind and body. That is what is required to be certified by the notary public. How does that person do it? The notary public will therefore be necessarily authorized to ask you questions, both about the contents of the document, as to whether you have understood the consequences of the document. He or she may ask you to tell him what is it that is contained in the document, and it is safer and advisable for you to answer those questions, so that this sentence that the document has been executed voluntarily without any coercion is recorded in on that face of that document, which adds veracity to and will validate the document at a later point of time. Now, on the other side lies the danger that if a notary public is not satisfied that this document has been executed voluntarily, he or she may refuse to execute that document, attest that document, because he or she may not be satisfied that you have executed it under your own volition. A classic example, if you are going with A and B, your family members who accompany you to the notary public may request that these two persons remain outside the room when the notary public asks you questions about the contents of the document. That is not to be taken as an offense. It is not to be taken as a question or a challenge to the authority of the persons who are accompanying you or to the relationship between you and them. It is not a question of challenging the trust. It is simply a question of the notary public being satisfied that this document has been executed in a voluntary state of mind. After you have executed, the document has been executed, a notarized copy of the AMD will have to be handed over to the guardian or guardians or the relatives that you have mentioned in the AMD. I mean, look at the situation. If you do execute an AMD and store it under your pillow or lock it up in your locker, there is nobody who is going to know that you have executed an AMD. And the purpose of an AMD is to let your family members or let the close relatives or the guardians know that I have executed an AMD, and these are the circumstances under which I do not want medical treatment to be prolonged. A copy to your family physician will have to be given if you have any. You will have to give a copy of this to a notarized or a nominated official of the government or municipal corporation or municipality or panchayat who is known as a custodian. It's a very sad thing, but in most of the states in India, a custodian has still not been appointed. Maharashtra is the only state who has appointed 170 and odd custodians at the grassroots level, right up to the state level. In fact, one of the famous doctors, I think, in Mumbai, was the first one to execute this AMT, and he was the first one to hand it over to the custodian, namely the commissioner of the corporation. So we will have to wait until a nominated official of the government is declared as a custodian. We are taking steps in Karnataka by moving the court of law to direct the state government to appoint a custodian. And if a custodian is appointed, it is necessary that the person who executes the AMD hands over a copy to that person. And if there is digital health records, you will be required to upload it on the site. Now, what is the procedure? The first step, if the executor becomes terminally ill, which means there is no hope of recovery and he's in a state where he is not going to survive. Second, if he is undergoing prolonged medical treatment with no hope of recovery and cure of the ailment, he does not have decision-making capacity. That's the patient does not have decision-making capacity, and the treating physician is aware of the AMD. This is why in the previous slide you saw that a copy of the notarized AMD must be handed over to your physician. Now, once these four conditions are satisfied, namely a person is terminally ill, has undergone or is undergoing prolonged medical treatment with no hope of recovery or curing of the ailment, and his decision-making abilities or cognitive abilities are impaired, and the treating physician is aware of the AMD, then the treating physician, that's a doctor, is required to ascertain the genuineness and authenticity of the AMD, either from the digital records or with reference to the custodian of the document. So the first level of protection comes here, where if a person produces an AMD, the treating physician is required to ascertain with reference to the digital records or with reference to the custodian whether this document is genuine or not genuine. So first step is that. Step two, The instructions that have been given in the AMD is required to be given due weight by doctors only if the doctor is fully satisfied, A, that the executor is terminally ill, is undergoing prolonged treatment, or is surviving on life support, or has an illness that is incurable or no hope of being cured. This is what gives the medical profession the shield of protection that was so badly required. The doctor has to be satisfied that the person is terminally ill. A cough or a cold or a TB or any of those diseases is not covered under an AMD. He must be terminally ill. He must or she must undergo going prolonged medical treatment. A 2-day treatment, a 3-day treatment, a 1-day treatment is not considered to be prolonged, or is surviving on life support. You may have ventilators. You may have a heart and lung machine. We don't know. So you are surviving, the person is surviving on life support, and that the illness is incurable or no hope of being cured. This is step 2 level of protection that the person who executes an AMD is given. Step 3. Now, if the decision is, the physician comes to a decision that these are the 4 conditions that we've talked about in the previous slides have been satisfied, and that the physician wants to act on the instructions, which means I want to pull the blood, the doctor wants to pull the blood. His duties are, number 1, the physician has to inform the guardians and the close relatives about what? Number 1, about the nature of the illness that the patient is suffering from. Number 2, about the availability of medical care for the illness that the person is suffering from. 3, also the consequences of alternative forms of treatment. It could be any other alternative form of treatment. It could be alternative in terms of homeopathy, it may be allopathy, it may be whatever else. 4, consequences of remaining untreated. This is the crux of it. The physician is bound and obliged to explain to the executor or the patient the guardian and the close relatives, what will happen if he is not treated. This includes the level of pain that the patient may have to undergo, the disability that the patient may undergo, the residual disability that the patient may undergo if not treated. 5, he must ensure that the guardian or the close relative understands the information that is given by the physician to that person. This is where an obligation is cast on the medical profession to communicate with the guardian or the close relative and explain in simple, understandable language without reference to the medical lingo as to what are the consequences and what is this patient suffering from, and ensure that this guardian or the close relative understands fully the information that is given to him. The doctor or the physician must also ensure that the person to whom this information is given, namely the guardian or the relative, has cogitated over the options, has thought over the options, and then given a decision, and then has come to the conclusion that withdrawal of or refusal of treatment is the best choice. Again, we come back to the original concept I talked about informed choice. In this case, the patient himself may not be in a position to make the choice. Therefore, the guardian or the close relative will make that choice. Now, what happens in a hospital? There is a hospital to which a patient is admitted. When there is an AMD in place and the institution is given a copy of the AMD, the hospital is required to constitute what is known as a primary medical board. This primary medical board comprises the treating physician. It may be a private physician or it may be a physician from or at the hospital. Treating physician and at least 2 subject experts of the concerned specialty with 5 years of experience. Subject specialists is what we call them. If it relates to the eye, then to the eye. If it relates to renal functions, then a renal specialist. They constitute a primary medical board. This board is required to visit the patient within 24 hours of the request being made. This visit must happen in the presence of the guardian or the close relative. Then the primary board has to decide whether to carry out the instructions of withdrawal of treatment or refusal of treatment. this decision is regarded as a preliminary opinion. You therefore have a third level of protection before the life is taken away. Primary medical board, visit within 48 hours with in the presence of the guardian and the close relative. They will decide carry out or not to carry out the directions contained in the AMD. This is known as a preliminary opinion. The next step, if the hospital or the institution comes to the conclusion that the preliminary opinion is to give effect to the AMD, namely to pull the plug, then there is another procedure that is to be followed. The hospital has to constitute a second medical board, which comprises one registered medical practitioner nominated by the CMO of the district, the chief medical officer of the district, two subject experts with 5 years experience who are not part of the primary board. The doctors or the experts who are a part of the primary medical board cannot become a part of the second medical board. This is the third level or fourth level of protection, because if there are two people who have already agreed as a part of the preliminary medical board, they cannot be expected to be neutral when they become a part of the second medical board. So a second medical board is constituted. This secondary board is required to visit the executor, and if the second medical board comes to the conclusion that the preliminary opinion which has been given by the primary medical board is valid and should be given effect to, then it will issue a certificate. The second medical board will issue a certificate saying, give effect to the terms of the AMD. This opinion has to come within 48 hours of the reference. Now, what is the other duty of the secondary board? The secondary board also had to ascertain the wishes of the executor if he is in a position to understand the consequences. After having come to the conclusion that we will give effect to the AMD instructions, the second medical board is taken to a next level of protection. It will ask, or it is expected to find out from the executor if he is in a position to communicate the appeal and where his cognitive abilities are in working order. They will ascertain the wishes of the executor and find out whether the patient has understood the consequences of withdrawal or given a treatment. If executor is incapable of taking a decision or has impaired decision-making facilities, then the consent of the guardian or the close relatives that have been named in the AMD, their consent will be taken. Now, look at step 6. This is the next level of protection. If the secondary board comes to the conclusion that we will give effect to the instructions in the AMD, namely, to put it very crudely, pull the plug, the hospital is required to convey the decisions of the primary and secondary boards and the consent of the guardian or the close relative named in the AMD to the jurisdictional junior judicial first-class magistrate. The judiciary steps in here. The hospital is required to submit the opinion of the primary board, of the secondary board, the consent of the guardian or the close relative, and place it before the first-class magistrate of the district and find out whether he sanctions the withdrawal or not withdrawal. Now, it is finally the JFMC who has to give permission and say, yes, you can give effect to the AMD and pull the plug, or say that we will not allow you or we will not permit you to pull the plug. The ultimate level of protection, therefore, comes back to the magistrate, who is expected to act after taking into consideration all the facts that have been placed before it. Now, what happens if the secondary board refuses to follow the AMD? The executor has given instructions as to follow it. What we saw earlier was where the secondary board agrees to follow it and therefore goes to the magistrate for permission. Now, what happens if the secondary board refuses to follow the AMD? Then the guardian or the close relatives named in the AMD is required to move the High Court and ask what is called a writ petition. A writ petition is a petition to the High Court or the Supreme Court, which essentially talks about enforcement of fundamental rights. And why does this petition have to go to the High Court? Simply for the reason that the right to life carries with it the right to die with dignity. Therefore, if the second medical board comes to the conclusion that we will not give effect to the AMD, then the guardian or the close relative is entitled to move the High Court and ask for a direction. The Chief Justice of the High Court is required to constitute a separate bench. A bench simply means two judges of the High Court, as opposed to a single judge of the High Court. The judge, therefore, the Chief Justice will therefore constitute a division bench comprising two people. Now, the High Court has also retained for itself the independent right to appoint an independent committee of 3 doctors from general medicine, cardiology, neurology, nephrology, psychiatry, or oncology, who have experience in critical care and overall standing of 20 years experience in the medical profession. This is the final state of protection, the final level of protection that an executor gets. The guardian or the close relative moves as High Court. The High Court is entitled to constitute an independent committee to assess the actual state of affairs and decide whether permission to be granted or not. There is a binding requirement that the High Court should hear this petition very expeditiously and decide in the best interest of the patient what should be done and what should not be done. The High Court is bound to be given an opportunity for the state government also to address arguments on this petition. The High Court, as I said, is entitled to constitute a medical board and examine the patient also and submit an independent report regarding the feasibility of acting on the AMD or not acting on the AMD. It is therefore the highest level of judiciary which finally takes the call as to whether the AMD should be given effect to or not to be given effect to. Now, there is an additional layer of protection. The contents of the AMD will not apply to the treatment in question if there are reasonable grounds to believe that the existing circumstances could not have been reasonably anticipated by the executor at the time she made the AMD. Quite simply, it means a certain set of circumstances, a certain set of facts, a certain state of the medical profession, a certain stage of medical facilities is available today. I am not in the position to figure out what will happen 5 years later. There may be new diseases, there may be new treatments. And therefore, I have not been able to put into my AMD those conditions because they did not exist today or I have no knowledge of. Therefore, there is a level of protection and says, if there is a possibility that the circumstances that could exist 24 months later could not have been contemplated by the executor when the AMD was made, then there are grounds not to execute the instructions given in the AMD. And if the AMD is not clear and unambiguous, then the medical boards will not give effect to the AMD. As we saw in the earlier part of the slide, it must be clear, specific, and unambiguous to say that this is what I would like, this is what I would not like to be given as medical treatment. If there is any case for, or if there are words and sentences and provisions that make interpretation difficult, then law errs on the safe side and says we will not give effect to the AMD. Now, if the primary board, going back to the primary board, if the primary board refuses to follow the AMD, the guardians are entitled to ask for reference to the secondary board, which is constituted. The secondary board goes on through the same process that they went through earlier. They will have to see whether the patient is terminally ill, whether he is undergoing medical treatment in respect of an ailment which is incurable, there is no hope of being cured, and the treating physician may inform the hospital. Now, once this information is given to the hospital by the treating physician, step 12 refers to a case where a treating physician gives intimation to the hospital. It may be a private physician, it may be your own doctor that you have, to whom you have given an AMD. If that doctor, the physician, gives intimation to the treating physician at the hospital that there is an AMD in existence, the hospital is bound to constitute the primary board, the secondary board, and go through the whole process that we talked about earlier before the life is plugged, pulled, plug is pulled. What are therefore clearly the barriers that come in the way of making an AMD? The most important one is that most of us do not understand the concept of an AMD. As I mentioned to you earlier, there is a huge misconception that an AMD is the same thing as the will that we make in respect to properties. Therefore, the first barrier is lack of understanding of AMD. Second, the inability to understand or visualize the possible medical conditions that may occur in future. Unless we are able to get access to medical information, unless the executor is able to have fruitful dialogue with the medical profession, assuming that the medical profession has the time and the inclination and the interest to convey these things to you, it is impossible for ordinary laymen like you and me to understand or visualize what are the possible medical conditions that I may land up in 5 years down the line. Therefore, that is the second barrier. Third, accessibility to information and time from medical professionals regarding medical conditions that may require AMD. Communication, time are two very, very significant barriers that come in the way of people deciding whether to make an AMD or not make an AMD. And impossibility to anticipate and provide for every possible medical condition. Just as the medical profession is moving ahead in finding cures for diseases that did not exist 10 years ago, it is not possible probably for laymen like us to even imagine or anticipate what kind of situation will arise tomorrow. This is where effective communication with the medical profession becomes absolutely critical before you decide and put down in an AMD what are the medical treatments that I want and what are the medical treatments that should not be given. And the most difficult barrier is unpredictability of the human body and the system. None of us know. Even doctors will not be able to tell you that this will be the result of this. Everybody as far as the human body is concerned, is groping. The human body has its own psychology. The human body has its own mind of its own. It will function the way it wants to, not the way you want to, not the way I want to, not the way the doctors want. So the barrier is about unpredictability of the human body and the system. There is also the inability to accurately visualize the pain or the suffering or the trauma that may accompany a medical condition. Let's just go back in our lives and find out the first time we burnt our hand when we put our finger on a tawa. Today we do not do it because we have experience of that pain. You have experience as to what happens if we touch a hot surface. We have experience of what happens if an electric shock comes to our body because we have tried to put in a plug or a wire where we should not. At our normal levels of cognitive levels, it would be impossible for any of us to accurately visualize what pain and trauma we would suffer at a later point of time from a medical condition. We therefore base our judgment on external narratives. We base our decision or determination of levels of pain and trauma based on stories we hear from people. But personal experience is lacking, and therefore that's a barrier. Then there is a barrier of guilt factor of family. Family may not want you to do it. There are ethical and moral issues here. Some of the moral issues, one moral issue that is raised is, who am I to take away your life because I'm not the one to give you life? These are outside the realm of logic. These are outside the realm of logical conclusions that the human mind may be able to conceive. Then there is a burden of decision. Am I as a family member, am I as a custodian, am I as a guardian or a close relative? Do I have the capacity to carry that guilt with me of the decision that I have taken? If I, as a guardian of somebody in my family, take a call to pull the plug, will I be able to live with that decision for the rest of my life? Because ultimately, we must realize that we all live on hope. We all believe that ultimately life will end when it has to end. Who am I as a guardian or an executor of this will or as a close relative to decide when to terminate life? This is a moral issue, an ethical issue, which we grapple with all the time in our lives. That's a barrier. Then there is this inability or reluctance to deal or discuss death. All of us have this habit of discussing. It's a taboo subject. The moment we talk about death, the moment we raise the subject of death, the standard answer is, why are you talking about this death? Leave it alone. It'll happen when it happens. So there is a reluctance to talk about death. The answer to this lies in the fact that there must be a dialogue with family members on the issue. The inability to have a meaningful dialogue, explain the concept of death, understand the concept of an advanced medical directive, the fruitlessness of prolonging life on artificial means are some things that the family together will have to necessarily discuss and shift this subject of death from the taboo list to the active list of discussion. And then there is the barrier of finality and irreversibility of once the plug is pulled, there is no going back. And this is one of the major factors that I, as a professional, have faced in talking about convincing people to make the AMD, because it is irreversible. It is conclusion of life, end of life. Now, the question is, once that happens, there is no way of reversing that decision. You're gone and dead. Therefore, that is a barrier. And then there is a very interesting theory of karma theory that comes in. Some of the more religious, some of the more philosophical, some of the more traditional people say, I come into this world with a certain balance of negative karma. I have to undergo the suffering. I am required by the theory of karma to undergo it so that I do not carry it into my next life. If I were to terminate my life today, either on behalf of an AMD, either by myself or through the influence of a guardian or a close relative, there is a debit balance of karma that I'll carry forward to my next life, which I don't want. Whether this theory is correct or not is a different matter, but this is just the barrier. And finally, the probability of misuse in this country is that. Therefore, what you need to do is understand AMD and its consequences, obtain complete information from doctors on possible medical conditions, have effective and meaningful, honest dialogues with the family, create an AMD when cognitive abilities are good. Just like the way we say, create a will also when you are in a fit state of mind and body. Determine the criteria for naming guardians of close relatives and obtain their consent to act as guardian and revoke the AMD the moment you are in doubt. Now, for just a quick list before I close, for example, artificial nutrition or hydration is a medical condition which you may not want. You may just want comfort care, what is called your hospice care. CPR, don't research. Today in the medical profession, DNR is in place. Do not resuscitate. It is being followed. CPR, I don't want a CPR. Pulmonary resuscitation. I don't want life-sustaining treatment. I don't want to be in a persistent vegetable state. If I'm in a terminal condition, I don't want to be. I want my life to end. You may want to be transferred to palliative care or hospice. You may not want a ventilator. You may want specific pain management. Do not resuscitate instructions, dialysis, for example. These are all very sample things that you can provide for in an AMD and say that I will not be put on dialysis. I do not want to be put on a ventilator. I only want my pain to be managed and not be given any active care because I'm suffering from an incurable disease. Therefore, this isn't bird's eye view, but ultimately the final word the courts have said is this. The healthcare provider will be guided by the person's best interest. And if the healthcare provider finds that the provisions of the living will or the opinion of the nominated person and family is not consistent with the healthcare situation, the healthcare provider has the right to disregard the living will. Therefore, ultimately, the final word rests with the medical professional to say, notwithstanding the provisions of the AMD, if I find that the guardian has given consent which is inconsistent with the provisions of the AMD, or that the patient is not in such a bad condition as we make him out to be, they are entitled to reject the AMD. Very bird's eye view of what the AMD is all about. It essentially will spring from your ability to handle this subject with the least amount of reluctance, with a great amount of positivity. And the procedure is cumbersome, I agree. But then the first steps have been taken from no AMD, no living will, to at least recognizing that there can be situations where the plug should be pulled. Thank you for listening. Now over to you, Nidhi.
Thank you so much, Shiv. I think that was very informative session. I can see a long list of questions. You may have covered most of these already, but I'll take them up nevertheless because I think it will be a refresher while going through these. So Prabhat has asked, as there is no specific format, does it need to be witnessed by one or two other people?
It is not the format that is witnessed. It is the fact that the executor has signed this document. We have, in fact, I think Nidhi will be circulating, if I'm not mistaken, a
Yes, I will
standard
be.
template that we have prepared, Silver Talkies has prepared. There is no specific format, but intentions must be clear as to when medical treatment should be stopped, when medical treatment can be given, what are the treatments that I do not want. The signature is not of the content. It is a fact of the executor having signed this in the presence of these two people, and that certify that the person who signed it knows what that person is saying. That's it. It could be handwritten, it could be typed, whatever. That does not matter.
Now, there is a question two questions which have come in, which are kind of similar. Yasmin had asked, what if it is, example, an accident case or an emergency situation where the person is not in a situation to execute an AMD? And another similar question was, can the AMD made after the person is admitted in hospital and is diagnosed with illness or a situation requiring artificial support?
Okay? These two questions are actually different, but anyway, it doesn't matter. In an accident case, as I've explained to you, an AMD is made when you're your cognitive abilities are in good state. So the question of your making an AMD after you're an accident case or you're an emergency does not arise, because it depends on the nature of the accident. For example, if you have a fracture on your hand, it doesn't affect your cognitive abilities. But if you're brain dead, or if you're no longer, you're medically alive, but not alive as you want to do it, and you're not able to, you're brain dead. That's what I'm saying. If you're brain dead or organ dead, then the question of AMD does not arise. Therefore, in an emergency situation, you will not be able to make a last minute AMD. The question, I think, is whether you can make a last minute AMD. No. Which is why I mentioned earlier, make an AMD when your cognitive abilities are in good shape, not when you're in an emergency ward of a hospital. If in an accident you are dead, you're dead. There's no question of AMD. But if you're so seriously injured, where you have a head injury, where you have a brain injury, where your survival itself is not at stake, then there is no AMD, and no AMD will be given effect to, because there is no AMD in accordance with the guidelines that have been laid down by the Supreme Court. The other question you said.
The other question was, if can the AMD made after the person is admitted in hospital and is diagnosed with illness requiring artificial support?
Once you're admitted to hospital, there will have to be a certificate that you're mentally in a physical state of mind to understand what you're doing. It's not as though you get admitted this morning and tomorrow say that I want to pull the plug. That will not be looked at kindly by the primary board or by the secondary board or by the high court or by the magistrate. So after you are diagnosed with a life-threatening situation, all those conditions that we talked about, It's incurable. You should have been under prolonged treatment for a long time. It should be terminal in nature. It is not a substitute for suicide. It is not a substitute for determining when I want to pull the plug, because all of us will want to pull the plug at some time or the other. If you had a switch in our respective bedrooms, we'd switch it off long ago. It's exactly to prevent that these levels of have been given. So after you are admitted to a hospital and you're on life support systems, making an AMD is not possible because you will not be in a medically fit state of mind, either mind or body.
Lakshmi has asked, are hospitals or doctors bound by law to recognize an AMD if a copy of the document is produced to them, a notarized copy of the document? They often tend to drag out keeping a patient in their care to run up huge bills.
This is a two-sided question. I will answer only the first part of the question. The second part is not in my control, and they relate to medical practices, ethical practices that I will, in my own safety, avoid, because I may get into one of those hospitals. But the hospitals and doctors are bound to recognize an AMD, provided the procedure that we have specified is followed. The primary board will have to be constituted. The secondary board will have to be constituted. If the secondary board comes to the conclusion that we will give effect to the AMD, they go back to the magistrate of the first class, who will ultimately say, yes, you can give effect to it now. Legally, therefore, they are bound to give effect to it, provided the safeguards that are mentioned in the slides I showed you are satisfactorily met. But if the question is whether the guardian or somebody of the family can go to court and sue the hospital for not following the AMD, no, that will not be available, because the procedure is prescribed under the law itself. Primary board, secondary board, court. If that is followed, then it's fine.
Yasmin has a question. Does the AMD have to be registered? If yes, with which authority? I'm sure you've answered that. But
I've answered that. There is no registration. Copies have to be given to the custodian. A custodian will have to check out whether they have been appointed in your respective areas where you reside. If so, a copy, and please make sure you get an acknowledgement. Because tomorrow these officers have a habit of saying, you have not given it to me at all. Okay, no registration required.
The next question is, how much time should pass before the doctor is satisfied on the prolonged period?
There is no statutory period, but the doctor individually will decide. It's within the scope of the medical profession. Usually, the law recognizes something is reasonable, maybe 2 months, 3 months, 4 months. I mean, how that there is no specific answer to that, because Shanbag was in PSV for 18 long. So it could be 3 months, it could be 4 months. It's a combination of several factors. What is the nature of the disease? Is there a cure for the disease? For how long? Maybe even a month, maybe a 2 month. Patient has been on treatment. Is there hope of recovery at all? Is he or she terminally ill? The time factor, the prolonged, is a indefinite term. It's not controlled by law. It is controlled by the circumstances that exist to determine whether it is prolonged or not. A week could be prolonged, month could be prolonged. Depends on the facts and the illness that we are talking about.
True. Okay, next question is a person or their family not entitled to withdraw a patient from hospital on their own responsibility? Does it always have to be only with an AMD hospital board's discretion?
There are two or three questions loaded into this one question. Withdrawing a patient from a hospital with or without the AMD has nothing to do with an AMD. AMD is not to prolong life, but to bring an end to life. Even today, you are entitled to withdraw a patient from a hospital against medical advice. They will give you a certificate saying this patient, we are releasing the patient against medical advice. So that part of it is still available. Now, AMD does not talk about you withdrawing the patient from the hospital. It talks about what treatment to give and what treatment not to give. That's about all that it does. It's up to you. If the guardian or the close relative who is appointed in the AMD decides that I don't want this treatment to be given, you're free to take the patient out. Then the general law steps, which is against medical advice. These two are not linked. AMD is only to ensure that the patient does not suffer and dies with dignity and nothing to do with withdrawal of the patient from the hospital. Yeah? Okay.
Okay, Priyanka wants to know, are doctors in critical care also being educated about the AMD processes?
Answer is I don't know. And I can only share an experience I had with a very big hospital when I took one of my family members for something else there. I talked to the head of that hospital and I said, asked him, Doctor, do you recognize AMDs? His response was, what's an AMD? That's where we are. I think that answers your question.
Uh,
Corporate hospital in Bangalore.
Do you have any information about how many AMDs have been handed over to a custodian in the country so far?
No, the only one that I know of which has been publicized in the newspaper is in Bombay. We don't have data on how many custodians have been appointed, how many people have actually handed over, and how many know that it has to be handed over. In Karnataka, for example, in Bangalore, Karnataka, we do not have a custodian. We are moving. I am moving a petition in the High Court asking for appointment. We have no statistics. These negative statistics are not available on any field. So the best thing to do is to find out from your respective BBMPs or your officers, panchayat officers, whether there is a custodian appointed. They will turn around and ask you what is custodian. That's a different matter, but you will have to make that effort.
So if I remember it correctly, Shiv, I think within our club, at least 3 members have worked with you to make their living, their AMDs.
Yes,
they have written their AMDs with your consultation. Yes.
They have.
Yeah.
Yes, they do.
So Margie is asking, in reality, do hospitals really follow the process of primary and secondary boards?
Again, I have no idea because this is internal information. This is classified information. We have no access to it. Unless a statutory board or law steps in and says you shall file some kind of information in some authority, we do not really know.
Question he's asking, can the AMD take effect if I am not in India at the time? Is this something which can be used elsewhere?
Yes, it's global territorial. If you are in a hospital in the US, this AMD may not take effect because there is a different law there that applies. If you're in the Europe and what is that other, Norway and all those places, you can say, I want lethal injections. They will help you to die. The former queen, I think, queen and king in Norway are one of those places. They actually had all their family members standing behind them and they went peacefully holding each other's hands. It was in the newspapers. So jurisdiction-wise, he or she can make an AMD in US to be operable in India. Yeah, sure. That can be done. Yes.
I'll just wait. Okay, so there's a question. If a person is in ICU and wants to go home, isn't the hospital bound to let the person go home even without the AMD? I think you
AMD has
answered
nothing
that.
to do with going home.
You answered that.
Question. Saying you want to withdraw a patient from ICU or from wherever, it's against medical advice. You take the risk, take them out. No problem. But if a person is in ICU and you have made an AMD saying that I don't want to be on a ventilator, that will be given effect. You will come out of the ICU not alive but dead because of the AMD. But if there is no AMD and you want to pull out the patient from the ICU, you will do so at your risk, and whatever happens will happen. Hospital is protected. It is no longer liable for that liability arising out of that death.
Usha says, thank you for a very informative and intense discussion. She says there are cases where the treatment has been withdrawn without an AMD. How is this decision arrived at? I think similar questions. How is the decision arrived at about withdrawing treatment without an AMD?
That is, if you are able to prove it, then it will amount to a criminal offense. You can sue the hospital. I didn't want to say it, but you brought it up for me. If there is no AMD, if there are no instructions to take the patient out, any conduct of any act of omission or commission by a treating physician to pull the plug without consent is a criminal offense, which is what this whole act AMD is supposed to protect. Yes, there you have a legal right. You can certainly take action. And get yourself.
Was this your question, or was your question different from this? Would you like to kind of unmute yourself and ask the question if you had a separate question?
Hi. No, that was the question, because with the consultation of the family members, the doctor has said so-and-so is, is brain dead, and there is no point in continuing with the treatment. So, I mean, we leave it up to you. So they've all, sat together and decided, okay, there's no point, and therefore you can pull the plug,
Valid, so, perfectly valid.
Yeah,
is that valid?
Perfectly valid, absolutely. Because it is the consent of the others, and there's a medical opinion that says he's brain dead.
Okay.
And
okay.
I mean, the only thing is you should have given you an alternative. I'm sure he or she would have, saying that he can continue to be on life support for years together.
Okay.
I'm sure that would have been conveyed to you. If not, it ought to have been conveyed. That's the pros and cons of a CCA. This is what we mean by an informed choice.
Yes. Got it. Thank you so much. Thank you.
Okay, Priyanka is asking, in my AMD, can I list out something like if my medical bill, is beyond a certain amount, then I want
the answer is no. I'm not even allowing you to ask that question. No, it's the physical state of the body. Illness, prolonged illness, incurable disease, no hope of cure, only then you can say pull the plug. No, because my medical bills are good. No chance.
Right. No. Mimamsa has asked for lawyer recommendations for making an AMD in Mumbai. Is it jurisdiction specific? Making an AMD? It's not. Yeah.
Not with technology at your command today. I mean, where is the question? You don't even need to see your client physically at all. All that Nidhi, the 3 or 4 we have done is online.
They have all been online, yes. So Mimamsa, you all, I think there are no questions. There are only observations and comments. I think Anita wanted to clarify that when she was referring to the loopholes that the guardians have to go through, she's not talking about the guilt, but it is about running around and the permissions which are involved. So it puts their lives on hold to help me die.
That's a nice way of putting it. But then that's not true. That's not true at all. What is this? Step 1, make up your mind. Second, get a draft done for which nobody else is needed. Go to the notary public. That's the only one where some physical help may be needed, or get the notary to your house. Then you deposit a copy of this with 3 people. That's it. And then wait for events to happen. Then the hospital takes over. The law takes over. There is no running around. Where is the running? Nothing, I would disagree on that, because these are the only 4 steps. It's not too much of a problem to get that done. When a notary will come to your house, there's no problem.
asking, is there a tentative duration for the whole process? How long does it usually take to kind of get all of the process steps done?
Depends on, again, who the lawyer is and et cetera, et cetera. Max 30 days, max.
Okay.
No,
I'm talking of the process after the information is made available. You're talking to your medical professional, getting information that I have no control over, or no lawyer has control over. After the data is made available, it should be over in 2-3 weeks. That's it. That's all there is.
Right. Okay, I think we have come to the end of all the questions. I hope everybody is better informed right now. And we will, as we said, we will send you, a template for the AMD, which you can look into. And in response to that email, you can reply back to us if you wish to get connected with Shiv to, kind of draft or finalize your AMDs as well. We will be happy to make that connection and help you get it done. So that is all, Shiv. Thank you so much for your time. We have recorded the session, so we hope to be able to put up the recording as well on our YouTube channel very shortly, and we'll inform all of you once that's done.